Welcome to the Monopoly Report. The Monopoly Report is dedicated to chronicling and analyzing the impact of antitrust and other regulations on the global advertising economy. If you are new to the Monopoly Report, you can subscribe to our weekly newsletter at monopoly-report.com. And you can check out all of the Monopoly Report podcasts at monopolyreportpod.com. I'm Alan Chapell. This week, my guest is Senator James Maroney from the great state of Connecticut. Senator Maroney was first elected to represent the 14th District, which is in Milford, in 2018, and he currently serves as the co-chair of the General Law Committee. Recently, Senator Maroney was named to the inaugural Leadership Council of the Future of Privacy Forum Center for Artificial Intelligence. Senator Maroney's work on tech legislation has been recognized nationally, and I've included the senator's full bio in the show notes. I'm excited to speak with the senator because I want to find out more about the process involved in passing a state privacy law. I want to understand how Senator Maroney got involved in that process and how he navigated the waters of industry lobbying efforts. I also wanted to find out more about the issues or concerns that Connecticut is looking to address over the next year or two via a privacy or artificial intelligence law. And maybe I can get the senator to give us a prediction on how the UConn Husky basketball teams will do this year. So let's get to it. Senator Maroney, thanks for coming on my pod. How are you?
Good, Dex. Thanks for having me.
Good. How are things in the great state of Connecticut right now?
Right now, it's a little rainy with the nor'easter that's coming up, but otherwise, things are generally good. Excited for the start of college basketball season up here as the center of the basketball universe.
Absolutely. I think there's two big games today, if I'm remembering correctly.
Exhibition games today, yeah. I need to check it on those scores after. I won't be watching them live.
Yeah, I'm looking forward to watching tonight. So I'd love to get a little context. So what's your origin story here when it comes to privacy legislation? You know, how did you come to take an interest in privacy?
Thank you very much. It's great question. I think, unfortunately, I don't have that exciting of an origin story. I wasn't bitten by a spider in a lab or anything like that. What I say is some people come to the legislature passionate about an issue, and sometimes an issue finds them. And I think I'm the latter. In this case, at least, the issue found me. I was just on the committee. Senator Duff had been passionate about trying to get Connecticut to pass, after the CPRA had passed. He had put in CCPA first, I think, then CPRA. But after California had passed CCPA, he had put in proposed legislation on privacy in Connecticut for a few years. And then it ended up coming to my committee one year. And so I really dug in and was interested. It's something, as far as tech is something I've been interested in. I was a small business owner, had made my own websites, worked, always seeing how I could include tech in the process. I was a tutoring business. When iPads came out, we were using iPads to record our sessions and to tutor on them. And so I got very interested and I really just dug in. And then it took me 3 years to pass our privacy bill. And so I've kind of stuck with it and fallen down that rabbit hole, and I just haven't come out.
Well, Senator, you are certainly in good company, because for many of us, we didn't land on privacy so much as privacy landed on us. Because just all of the impact and the number of things in our society that it touches on. So I'd be curious to understand a little bit better. You said it took 3 years to pass the Connecticut privacy bill. What took so long?
Yeah, so the first year, and it couldn't even get the bill voted out of committee. It definitely the most lobbied bill in the Connecticut legislature for all of those 3 years. And, fun fact, Connecticut charges sales tax on lobbying services. And so I like to say whenever I ran a task force meeting or held a call on privacy, I generated $1,000 in sales tax revenue for the state of Connecticut. So for every hour that I ran, but it was definitely a heavily lobbied issue. It's an issue that is difficult for legislators to understand, and so a lot of times people would go to my colleagues and say, "Well, one thing is we won't be able to fight the pandemic if this law passes." Well, that's not true. They did this. They had these laws in effect in California, and they did fine.
Well, we are really good at coming up with excuses. It's sort of like the dog ate my homework type of a story, except for, now several years later. But You mentioned industry lobbying efforts and, recognizing that they can have a pretty significant impact on some of the state level legislation. What are some of the challenges that you faced coming up against some of those lobbying efforts that might have pushed back as you tried to craft the privacy law in Connecticut?
Yeah, as I said, that the first time, and it was actually really going to be a very basic bill with just a task force and a privacy notice, and we couldn't even require a privacy notice, and we couldn't get that out of committee because they were able to turn some of my colleagues who had said they were going to vote yes to say they were going to vote no before the last day of their committee meeting.
I'm just curious, when you say it was just a require a privacy policy law, I mean, the FTC has basically required one for a decade and a half. So what was the objection? Or is there something here that I'm missing?
Yeah, no, I think it seems like a lot of times when you run bills that people say, well, I don't object to that, but it's a slippery slope. I know if you're going to do this next, you're going to do that. And I think that in the end, we were willing to, and we hadn't drafted the new language yet. I had told people I was going to amend it to be a privacy policy with a task force to study, and then we just need to get the time to do that, and then they just did not. We didn't get the time to get that out of committee. The next year, we were able to get it out of committee, and then we were able to get the bill out of the Senate. It was part of the budget bill, so a larger bill, and then the budget was amended in the House to strip that piece out. Because again, the heavy lobbying of people in the House, some of them, from what I understand, some of the lobbyists said I refused to talk to them, which I did get FOI'd at one point. I think 1,000 pages of emails between myself and the people I refused to talk to, but but there was a lesson, right? And in the next year, we ran the process. I just ran the working group that I had put in the law as if the law had passed, and everything was done fairly publicly. We had a lot of meetings that were out in the open, and I also, I learned to make sure that you had someone from the House who could verify all of the work that I was doing in case there was a question there. And Representative Arconti became my champion in the House and worked through everything with me. And it's one of those things you learn that it's not just getting it out of one. You have to get it out of both the Senate and the House. So making sure you have champions in the other chamber is critical. So we definitely learned a lot from those two attempts. And then we got it through in the third year and out of a lot of work. And the nice thing was, I think I was in a really good place. And then the ironic thing is that after that other year, the bill is arguably stronger than what we had passed. That I got stripped out of the House that time, in that initially we did not require, we put the global privacy control as optional versus where we passed the actual law the next year through both houses. It was mandatory as of January 1 of 2025.
Well, not just that, but then Connecticut came back not once, but twice after passing the initial bill to strengthen it. So there is something to the slippery slope argument, I guess you could say.
Yeah. I guess true.
So you mentioned the global privacy control, and Connecticut is, off the top of my head, it's something like half the state privacy laws right now have some reference to either the global privacy control, which is a sort of the do not track 2.0, the idea that there's something within a browser that a user can just kind of turn on and that'll stop sale, share, profiling, ad targeting. And so Connecticut has that, and which is interesting in and of itself. But from my perspective, what's really interesting is that I believe there's sort of an anti-preferencing measure in there too, where there was at least some consideration that the browser purveyor might have a competitive ad product, and it was unfair, or at least unwise, for that browser purveyor to necessarily use the global privacy control as a wedge to preference their own ad services. And I'd love to know the backstory on that.
That, a lot of the bill was passed in working with our AG's data privacy unit, and I believe that had become one of their priorities. And Michelle Lucan, who is the head of that unit, as she said, why that was important to her. I hate to speak for someone else, but what I've heard her say at our conversations is that it shouldn't be hard to exercise your rights, and so we wanted to make sure that people could exercise their rights to opt out and make it a little easier for them to do so. And so that just came in working closely with their office and the drafting. And again, over that extra year, we spent a lot of time with industry. Right, I worked closely with industry, but also with the AG's office and some advocates as well. We worked really well with Consumer Reports. Maureen Mahoney was at Consumer Reports at that time. She's now working for California privacy agency, but we worked closely with some of the advocates through that process.
Which is great. And you raise, I think, an important point here that opt-outs should not be difficult to enact. There's sort of a flip side of that, which is that, default settings, if you set things up so that a consent is required for everything, I would argue that approach should just much more of a European idea, although it seems to be making its way into the States. The consent approach is not necessarily the right approach either. And so, how does one strike the balance?
Yeah, and that is, right. How do you balance user experience with protecting people's rights and understanding, as you mentioned, we did it earlier on, how privacy is fraught a lot of because it is part of everything. People don't realize how much data they're generating. So what is our obligation to protect people from what they don't know? Our potential, not necessarily if it's a harm, it could lead to a harm. We don't know, but if they don't understand how their data is being used, it is that everything is a balancing act. I feel that it's trying to balance and it strike a balance between the various interests in there.
Yeah, and what sometimes doesn't get, it sort of gets acknowledged at a high level, but at the ground level, it doesn't always get acknowledged that there's trade-offs in play for just about every decision that one makes. And look, I tend to come at things from a more of a pro-industry perspective, but I'm certainly on the side of consumers as compared to a number of others in the industry who it's just sort of like, well, let's make this as difficult as we can, make things confusing, make things opaque. I just don't think that's a good policy. And I want to shift topics a little bit. So the Connecticut State Privacy Act, and like many of the state laws, has a broad definition of personal data. I believe inferences derived from personal data even count as personal data. Connecticut's not the only state to do that. I think a number of them do that. But I'm curious, how does the concept of de-identification, which is something that, like a term that, back when I was focusing more on HIPAA, the health privacy law, like I get what de-identification means in that context, but I struggle with the way some of the state laws are crafted that I don't know where personal data ends and de-identified data begins. And I'm just curious if, you and your colleagues had wrestled with that conceptually.
As we were crafting the original bill, there was definitely we had to consider the de-identified, other privacy enhancing ways, anonymous data areas to be for the advertising and just making sure what should be exempt. We probably didn't end up doing as much as we should have to incentivize privacy enhancing measures. And that may be something, to look at, when you talk about creating that experience. Right, the user experience and having to click on accept all or reject all the time, it definitely can detract from your experience. And also just preventing, as you mentioned, other automatic things from happening, right, based on where you are, or automatic recognition or other things that can make it easier. So we didn't put as much, incentives in there to do other privacy enhancing methods as we probably could.
Yeah, and I think you hit the nail on the head. With an overly broad definition of personal data, which kind of makes sense because you want everything covered under the ambit of the law. But I think you're right in that debatable whether that incentivizes the business community to adopt privacy safe measures. Because if everything's personal data and it's still subject to the same rule set and there's no way to pull a data set outside of the rule set, the business community is just going to say, well, I might as well collect as much data as I can. I mean, and so the beauty of, I think, of this process is that, Connecticut may very well go back and continue to update. And, this is going to be an iterative process, at least until the federal government decides that they want to take part in this in a meaningful way.
No, I mean, that's what we say. We're writing laws. We're not etching commandments in stone tablets. And, one of the other areas of cognizance for my committee is liquor. And we pass a liquor law every year, and liquor is thousands of years old. So I think that we'll be back to modify these privacy laws.
So I just remember from growing up in Connecticut, and I don't even know if these are still a thing there, but the 8 p.m. can't buy beer law and then the Sunday can't buy beer law. I didn't know that other states operated differently. So when I moved to New York City and I found out, wait a minute, it's 10 o'clock and I can get a 6-pack of whatever. Anyway, there's no question in there other than I hope eventually Connecticut has rolled some of that back.
Yeah, about 10 years ago. So a little late to the party, but better late.
Well, that's
than
what I try to
never,
do here. I want to take a strong stand on laws that have already passed 10 years ago. That's what we do here at the Monopoly Report. Oh, my goodness. But you've mentioned that, Connecticut has updated the privacy law a couple of times. What do you think is on the hit list? I'm not trying to commit you to anything, but what other things are you looking at right now? I mean, I would imagine AI would be part of that, but is there anything else?
I think after what happened in Minnesota last year, where the legislators, the Speaker of the House was killed in her home and other legislators were shot, or he went to another legislator that I know to her house and she wasn't home. And there's Ring doorbell footage, and all of the information he compiled was from publicly available websites and data brokers. And so there is a lot of talk of states doing either some form of Daniel's Law, which is passed in New Jersey, likely in Connecticut. We're looking at the Delete Act from California to see if there would be any way of moving towards the Delete Act. But I need to get updated because they have to build a mechanism, and does it make sense for a small state to do that? Would it be possible to in some way combine with them? So there's still a lot of thought that needs to go into that, but likely looking at a data broker registry and then the Delete Act with a delayed implementation in Connecticut for next year, I would say. I think there was, I read the bill so many times, and then you have people look at it and edit it, and then when it finally gets voted on, a lot of hands have touched it, and then I just realized there's some grammar things, not necessarily grammar, but the wording. We don't define sharing in there, and there's a place where all of a sudden we brought in sharing for no good reason. So I think I may need to go do a little bit of cleanup if I'm opening the bill up next year, but nothing major. We did some updates, as you mentioned. We went back, we did children's protections, we did consumer health data. And then this last year, we made some more significant updates, but a lot of those came with trying to tighten some of the exemptions. And that came out of, the Attorney General gives a report every year on enforcement. And so a lot of the complaints they received fall under one of the exemptions. So we had tried to narrow some of those down. I think one thing we may go back at again next year is looking at the publicly available information definition. We tried to narrow that. We didn't end up doing that very much last year. I know a new definition was passed in Vermont as part of their age-appropriate design code, which we may look at. But the other exemption we did tighten was the TLDA exemption. So we went to insurance and banking as regulated by the state. We were seeing in Texas, there were car dealerships that had claimed the TLDA exemption and others because they had financing units, and we weren't intending that whole entity to be exempt.
That's a lot of stuff. But one thing that came out of that I'd love to dive a little bit deeper on is I think you were saying that there has been, some communication and maybe even high level coordination amongst different states. I thought that was primarily at the enforcement level, but it sounds like at the legislative level, you guys are talking. Is that a fair statement?
Yeah, we still talk pretty regularly. I mean, there's some other state legislators I talk with several times a week. But, as far as a group, we had built a multi-state AI policy working group where we had been meeting once or twice a month. Our email list is over 250 legislators, 48 out of the 50 states. We did meet again a week or two ago. We're going to get started back up and bringing in, similar to how I ran my task forces, or a lot of us do our task force. We do 2-hour meetings, like 30-minute blocks, where we bring in different experts to talk on topics. And looking at actually after this podcast, I have another meeting where we're going to try to lay out all of our upcoming meetings on AI. But as part of that, we also are planning on having a meeting to look at the enforcement of the state privacy levels, because really a privacy law is the basis for any AI, anything you're going to do with AI. And I think for any state, my recommendation is usually do privacy first before you would look at doing something. Obviously, now there are more specific, like because AI is so general. So if you're looking at self-driving cars or other are very specific, but most things, I think it makes more sense to do a data privacy law first before doing AI regulation.
So I noticed that you were on some kind of an advisory board as it pertains to AI for the Future of Privacy Forum folks. And just so you know, Jules Polonetsky is an old friend and a friend of this podcast. Same with Doug Miller. I'd be curious to hear more about what you see as your role within the Future of Privacy folks.
Yeah, so the Future Privacy Forum, first, they convened our multi-state working group. They were nonpartisan conveners. They didn't write policy, so they helped us with organizing, getting the Zooms together, helping us getting speakers. Unfortunately, they came under some fire for that, and so they're no longer serving as our nonpartisan convener, which, again, I think it's shameful because we're legislators who are doing our due diligence. State legislators, we don't have huge staffs. Most of us have full-time jobs doing something else, and we're trying to work together to dig in to avoid the feared patchwork and to try to coordinate definitions. And so we were working, across party lines, across states to try to bring in experts and talk. But I'm also on their, the advisory committee for the AI Center. And so that would just meet a couple times a year, and they get to add, they'll ask some questions and we'll get to provide some feedback. So yeah, I feel lucky to be able to sit in on those meetings and hear from different experts from around the world.
Yeah, Jules does a great job dealing with very thorny issues in a way that generally rises above the political fray. But that doesn't mean he doesn't get shot at occasionally. And it sounds like there was a little kerfluffle there over that, which is unfortunate because those guys are doing some great work, and it's good that you'll be able to leverage it.
Yeah. And we're going to continue, and Princeton is now going to serve as our convener, the Institute for Tech Policy at Princeton. So,
great. Okay.
So we'll continue the work, and Future Privacy Forum is going to continue providing their great resources like they have to legislators and companies, and serving as a forum.
So when it comes to sensitive personal data, things like health, location, race, biometric, sexual interest, a number of states have started to move beyond a opt-in consent standard and have kind of crossed the threshold into an out-and-out prohibition. And I'm curious to understand what you see as the Connecticut approach to regulating sensitive data. Do you see Connecticut moving towards more of a prohibition, or are you sort of feeling like you're pretty comfortable where things sit? And maybe it's about expanding the definition of sensitive.
Yeah, and so we had expanded the definition as part of our update last year because we were the fifth state to pass our law, and since almost 15 other states have passed laws. So we looked at the definitions from a number of the other states, and we felt we had to update ours, right? And so that was one of the keys. We were looking at, initially to see whether we should consider like a data minimization or, to only collect sensitive data if it was strictly necessary. I guess the debate came down to it shouldn't be a choice. I guess if it's opt-in, then should people be able to give their permission to have that data collected? So that's kind of where we ended up. We did tighten slightly, like around the purposes, using some of the rulemaking from Colorado and California. but we didn't end up on a strict data minimization standard this last year.
From the perspective of most of my audience, which is the digital media space, so I'm probably oversimplifying maybe a bit, but the distinction between an opt-in consent standard, because most of them really aren't getting a consent for just about anything. So the distinction between opt-in consent and prohibition is almost meaningless, because from my perspective, I think opt-in consent for things that are sensitive is probably the better route to go. You just want to worry about the government being perhaps too paternalistic with, prohibiting things. Now, that might be different for children, then that's a different story. But for, if somebody wants to agree to something, generally speaking, as long as it's clear and they understand the terms. And I'm not trying to beat up on Maryland and some of the other states, but I'm just kind of sharing to the extent that there are other legislatures out there listening and taking cues from me, which may or may not be happening. But to the extent that they are, I thought I would share that. So like many of the states, Connecticut requires companies to honor opt-out requests from authorized agents. So companies that make requests on behalf of consumers. Do you see Connecticut as potentially looking to expand the types of requests from authorized agents that companies would need to honor? Because I think right now it's mostly limited to opt-out signals.
Only on prospective, right? So an agent could opt you out of the sale of your data, opt you out of things going forward. I was a little nervous, initially, like to allow for an agent to access your other rights, to delete your data or to get a copy of the data. I right now don't see us expanding beyond, where we are. Because I didn't see if you had opted out of the sale of your data or tracking for advertising, I felt that was an easier harm to come back from, right? If it was done wrong, and wrongfully done by someone, misrepresented. And again, they have to be commercially verified. I understand all of that, but that was my thinking when we established which rights that an agent could exercise on your behalf.
So the challenge that I'm seeing within the authorized agent community, most of them are legitimately trying to serve a commercial interest of consumers who just don't understand all of these companies collecting data on them. That said, there's a decent sized portion of that industry that is making promises that they aren't clearly articulating. They think their job is to send out requests to as many different entities as they can and aren't really doing any due diligence on whether or not, a company happens to fall into the category of data broker. There's all kinds of issues there that I've been privately encouraging that industry to figure out their own self-reg, because sooner or later, some state or some AG is gonna start to take issue with that. And they've gotten a little bit of a reprieve around the click to cancel rule set, because that doesn't seem like that's going anywhere right now. But that would have been a big problem for a lot of these guys, because it's often an amorphous value prop. So I'm encouraged to hear that it doesn't seem like Connecticut is necessarily gonna be doubling down. I'm just sort of curious, though, outside of something like the global privacy control, how does an authorized agent even make a request when it comes to like an ad tech company who's mostly dealing with, device data?
And one of the things, in Connecticut, we, at least in our data privacy law, we have to kind of, in the legislation, write in everything we want, because our AG doesn't have rulemaking ability. And so we can't write something in and let them clarify later. So the actual mechanism, I'm not sure.
And I think the answer is, like, I'm probably looking at this too myopically via the digital media space, because there are certainly plenty of companies who are in the identifiable personal data space who an authorized agent could make these kind of requests on behalf of somebody in a way that makes sense. And it's like, okay, my email address is Chapell@gmail. Like, okay, somebody can make a request on behalf of that. And that's easy enough. It's just a little harder to do with pseudonymous data. So bonus points for sticking through what is admittedly a poorly thought out question. So thank you. But you mentioned rulemaking, and I want to dive into that a little bit, because thus far, and correct me, Colorado, California, and New Jersey are the three states that currently have rulemaking. And thus far, there's been mostly parity across the states in terms of the rule set. not identical, but pretty close. Like there aren't too many outliers, maybe other than the prohibition from Maryland in a couple of places. So I'm curious, how do you and your colleagues balance state action on privacy and AI with either Commerce Clause concerns or just general consistency across states? Is that a big concern?
I would say yes and no. So, yes. I think that, one of the things you were always taught is people don't want the patchwork, right? The feared patchwork. And we do look to keep definitions consistent, but then everyone does tweak them. So, so we start with the goal, but, there are lots of groups. So like a lot of the legislators were part of the NCSL as the Cybersecurity, AI, and Data Privacy Task Force that meets a few times a year. So, and then some of us are also part of the working group, that multi-state AI working group where we'll also talk data privacy. So I think we're definitely more in touch with each other now than back when I had initially started working on that. And the whole thing started, I just reached out to Senator Rodriguez after I saw his bill got out of Colorado, Senate 35-0. I was struggling to get it out. And he responded, probably biggest mistake in his life. He probably goes back and regrets that day. So we'll have to, after he gets that change, if you could change one decision in your life, I never would have emailed Maroney. But we've become great friends, and as I say, misery loves company. So we're trying to build more privacy legislators to all come together and share in this unique experience of working on the legislation. So we do, I talk with lots of different legislators now, and there are lots of different forums where we're able to communicate with each other and try to stay on top of it. Obviously, Future Privacy Forum puts out great reports. A lot of other groups put out great reports. NCSL puts out reports on all the legislation that's passed. And so that's usually the start, is to look at what other states have done and then start from there.
Yeah, you can usually find the handiwork of Law A in Law B, C, and D's initial drafts. There's stuff that gets pulled directly out of the GDPR in drafts that I've seen from different states. Because it's a great document. You got to start somewhere. And so you're like, let's borrow from there. And then, but the challenge then becomes there's always a hidden comma or period or definition in there that doesn't belong, that you've got to kind of figure out, all right, well, how do we include this into the thing that we're ultimately trying to create?
The one thing that's interesting, like we all just copy each other. So the 1,750 feet, right, for the precise geographic location. I think one state changed to 1,650. But we were all sitting around like at a conference, and we did having a drink, and we said, "Who came up with that?" We're like, I don't know. Why is it that way? I don't know. It just was.
It does kind of make sense. Like you get what that is now. Okay. Yeah. You're doing a geofence within this, this proximity. Okay.
Yeah.
Just an aside after about 11 other asides over this entire interview is a series of asides. So if the one thing that I think would increase the likelihood of a federal privacy law exponentially would be inconsistency across the states, like crazy inconsistency across the states. Somebody has opt-in for everything, somebody is opt-out for everything. Somebody defines personal data as X, and then somebody defines it as Y. That's the type of thing that I think would ultimately enforce or push the federal government to do what they did in 2004 or 2003, when everybody was freaking out about a California opt-in email law, that in a month and a half, Congress got the CAN-SPAM Act passed in response to that. And so I'm not saying that you should be aspiring to push the federal government.
So Alan told me that I have to pass a law that's different than everyone else.
But it would sure help us out, because right now, 20 states and counting is it's great for the privacy lawyers. I don't know that it's great for consumers entirely, and I don't know that it's great for businesses. That said, this isn't a problem of the state's making. You are stepping into a void, and what you're doing is far better in most cases than the void. for whatever that's worth. But let's say, hypothetically, that the federal government awakens from its 25-year slumber and decides to pass a comprehensive federal privacy and AI law, but that it preempts the entirety of state-level action on both privacy and AI. Is that a good thing or a bad thing in your view?
I think I'm going to give a lawyerly answer and say it depends. It depends on, is it a weak law or is it a stronger law? And I guess, and again, that's also in the eyes of the holder, I guess, what's weak and what's strong. But I think that a number of us would agree that the federal action would ultimately be the best. I think our preference would be more to see a federal floor rather than a ceiling, right? To set, like with the minimum wage, there's a national minimum wage and states can go up higher, but, there's certain baseline protections that as long as people had those critical protections, it would at least feel that we contributed towards making that happen.
I think that's a great answer. And I still rack my brain trying to figure out when we're going to get to that point, because I don't even think anybody disagrees that we're going to get to that point. The question is whether or not that's going to take a year or another 10 or 15 years. Hopefully it's much closer to the former, but I guess we'll see. There's been some interesting incubation at the state level that I hope does not get entirely lost at the federal level. But I would say that, not just in privacy or even in digital media, there's been a whole bunch of things. And so hopefully the federal government is able to eventually get itself together to the point where they can push some things through. I think one of the things holding that back is the private right of action. I don't really know a good answer to that, but I will say that both sides, those pushing for a private right of action and the business community generally pushing against it, are not always making consistent or honest arguments about it, because you cannot look at what's going on with the Video Privacy Protection Act and the California Information Privacy Act and the amount of havoc that is causing on the digital media space and not wonder if there's a better approach. On the other hand, I'm sorry, I'm filibustering here, but I'm just going to go with it.
Yeah.
On the other hand, I do think that it's valid to say, outside of California at least, that most states are not going to have the budget to adequately enforce their laws. And, you can't just shrug your shoulders and say, oh, well, to that either. And so hopefully, at some point there can be a happy medium which allows at least some level of reasonable enforcement. I have not thrown a question in there. I'm just going to open it up and say, what are your thoughts?
Yeah, I get the argument. There's no rights without recourse. I just don't want to pass a bill that creates a new cottage industry of chasing after, especially if we're smaller companies, for tic-tac violations. So I think you're right. There has to be at some point, hopefully we can figure out a way for that medium. Because, we saw with BIPA what happened with all of the lawsuits in Illinois. And so there was, California, their two chatbot laws this year did have private right of action for harms that are done. And so maybe that's the way, or maybe you have to go towards allowing a certification before a lawsuit can go forward so that you don't have as many frivolous lawsuits. But, my thing is I'm pragmatic, and I hadn't seen many bills that were able to pass with the private right of action. And so it just, for me, it has been a non-starter, although seeing the chatbot laws, I think next year I am going to be running a chatbot law. And so I will start with something similar to what they have in there, and we'll see where we end up. But it seems like there are two poison pills federally, preemption and private right of action. I think the last privacy bill they proposed had both poison pills in it. So we'll have to see where we end up going for. But I like the way you said that. At some point, we have to find a medium.
The last couple of rounds with the federal privacy law were always kind of hilarious, because you'd get something that is like you're at the 2-yard line. Kind of like everybody agrees on everything else. And then, but we just got to figure out this private right of action and preemption issue. And then at that point, everybody throws up their hands again and walks away from the table. And we seem to have, it's been like the Charlie Brown and the football thing for a number of years over those two issues. So we'll see. So Senator Maroney, this has been an absolute pleasure. I really appreciate you coming on. I've got one more question for you, and it's a tough one. What will the combined record of the UConn basketball men's and women's teams be this year?
I'll give you the combined losses. I think between the two of them, they're going to lose 4 games. That's it. I don't know which 4, but the men usually have a slump in January at some point, and then they come on strong at the end. I'm excited. This is actually it's a good time to ask me that question, because this will be the first year I have both men's and women's seasons tickets in Hartford. So I've been a men's seasons ticket holder for a long time. This year I also got women's seasons tickets, so I split them with my brother.
Oh, that's fantastic. Fortunately, they're playing at MSG, I think 4 or 5 times, not even including the tournament this year. So absolutely a boondoggle for anybody, any of the literally millions of UConn fans in New York City.
I'll be there November 28th. They're playing the University of Illinois. So if you're going, you can meet my son because we're going then. And November 15th, they're playing in Boston against BYU. Both are preseason top 10. Yeah, it's gonna be a fun year.
Yeah,
I'm excited.
Senator, I will be at that game, and so yes, I would love to meet you and your son. This has been a fantastic discussion. I really appreciate you coming on, Senator James Maroney. Thank you.
Thank you so much for having me.
That was a great conversation. A few thoughts. First, if anyone thinks that state-level politicians are not on top of the public policy issues around privacy, well, think again. I love that the senator is leveraging the Future of Privacy Forum and the good people at Princeton to stay on top of all this stuff. Second, it's interesting to hear that the state legislators are working together and comparing notes. I loved the backstory around how the legislators came up with the definition for precise location data. And it sounds like Connecticut is planning to borrow portions of the Delete Act from California. In other words, we're going to see lots more cross-pollination of ideas across the U.S. states. Third, I was pleased to see the senator recognize that there are risks associated with the practices of authorized agents. I still think that California has unleashed the concept of authorized agent on the marketplace without much regard for downside risk. And while most of the authorized agents are trying to serve a legitimate business purpose, some of them are not, and it's just not helpful. And finally, I think that the senator and I are generally aligned that we need to figure out enforcement of privacy laws, particularly for states that don't have the resources of California. Private right of action, as currently construed, isn't the answer. But status quo isn't necessarily the right call either. Someone needs to figure out those issues if we're ever going to see a federal privacy law. And if we want to move forward on all this, I think all sides need to start having more honest conversations with each other. We have a bunch of other fantastic guests coming up on the Monopoly Report podcast over the next few weeks. For example, I'll have Cory Doctorow in to discuss his latest book on enshittification. We'll have Doug Miller in to talk about career paths for privacy and regulatory pros. And I'll have a few big names from the U.S. federal government ranks coming on soon. Please subscribe to the show at monopolyreportpod.com or on Spotify, Apple, YouTube, or wherever you listen to your podcasts. And thanks for listening.
Thank you for listening to the Marketecture Podcast. New episodes come out every Friday, and an insightful vendor interview is published each Monday. You can subscribe to our library of hundreds of executive interviews at marketecture.tv. You can also sign up for free for our weekly newsletter with my original strategic insights on the week's news at news.marketecture.tv. And if you're feeling social, we operate a vibrant Slack community that you can apply to join at adtechgod.com.